We need to treat our parkour businesses like they are actual businesses.
Is it even worth it? Ignorance of the law is not a defense if you get sued.
At that point, just how much do you want revenge?
Let's work now to head off problems in the future.
What's up, parkour business owners? It's me, Jimmy Davidson from Motion Mentors. I am joined by Matthew Becker once again from the Gym Lawyer. Matthew, how you doing today?
I'm good, Jimmy. How are you doing? It's good to talk with you.
Yeah, absolutely. Matthew, I've had a few inquiries over the past couple of months of parkour gym owners, parkour program owners, just having some issues, a couple issues with landlords, a couple issues with contracts, either being existent or not. Couple instances of folks just not getting paid for their services rendered. And so seeing all those kind of come in at once, I thought it was a great opportunity to reconnect with you since you are a Motion Mentors brand partner on our legal side, just to give some advice to those gym owners in that situation and any future gym owner who may, need a contract soon or start a lease soon or be working with a third party. So let me kick things off with one instance that you actually did help us with. We brought you in for this parkour gym owner in the Midwest, and they were having this situation where the building owner was just totally neglecting their responsibilities to fix the roof or to fix the electrical or basically keep the building into code and into compliance, which was, I think, on their contract, although you reviewed it and may have found some holes. So yeah, let's start there. What was your hot take on that one?
Yeah. Thanks, Jimmy. And just as we get into the episode, the Gym Lawyers PLLC is a legal consulting firm, and while I am a practicing attorney, I would say that anybody listening to this, don't take any of this as legal advice. I don't know you. I don't know your specific situation. We have no attorney-client privilege. It may sound very similar to something that you are experiencing or may experience in the future, but every situation is different. Every state is different. Every contract's different. And so these are general principles that you can help to apply to your own business, but we always recommend reach out to us or other legal professionals to get actual legal advice for your situation. And so with that said, anytime we're dealing with something like a commercial lease, okay, the first thing we have to do is turn to the commercial lease. And so, it's sort of like the classic, it depends lawyer answer, right? The client calls up and says, I'm having this problem with my landlord. They won't fix XYZ. We're trying to make them fix XYZ. Can we force them to do it? It depends on what is in the commercial lease. Now, luckily, from our perspective, everybody, any listener here, unless you own your building, you're going to have a commercial lease. And commercial leases are typically very nice, long, drawn-out legal contracts with a lot of very specific language, which makes it very easy from our perspective to then have the client come in or, meet on Zoom, and we look through the lease. We apply to their situation, and we say, yes, you can go after the landlord for this, and here's how you do it. Or, no, you can't, because here it is in black and white that says XYZ is your responsibility. So with commercial leases, it's nice because usually it's pretty clear black and white. Doesn't always mean it is, but in that instance, it's really helpful to have that commercial lease in hand to be able to know what are the responsibilities of each party.
Okay. So I suppose before you sign that commercial lease, you would want to get really clear on, what does it say? And what are your responsibilities? What are the landlord's responsibilities? And what happens if there's a disagreement? Matt, do you have any, I guess, tips or advice on starting that negotiation process? Things that really should be in there that you should look out for, reviewing the lease, not just giving it a scan and saying, yep, it's a lease. What would you give a business owner there?
Yeah. So I think part of the theme that's going to ride through this entire recording is, the formality that we come at a business from the legal perspective, and our encouragement that any business owner, but in this instance, parkour business owners, treat their businesses like quote unquote real businesses. Okay. When I got into the gym industry, what was it, 11, 12 years ago? It was like I opened up a CrossFit gym and it was supposed to be like a hobby. And then a lot of professionals came out and started saying, look, you guys got to treat these like real businesses. And that's why people like you exist, Motion Movers, because you've done it. You know how to run a business. And now you can mentor somebody else on how to run their business. And I say all that because part of this is understanding that your lease agreement is perhaps the biggest, largest, most expensive legal contract you will ever sign. Probably second only to if you buy a house, right? So you're agreeing, let's say an average commercial lease is $3,000. The average lifespan of a commercial lease is 5 years. You multiply that out, that's over $150,000 that you are legally obligating yourself, either on behalf of your legal entity or with a personal guarantee. You are obligating yourself to pay. And I would say, like, please do not sign a contract obligating yourself to pay $150,000 if you are not crystal clear about what is in that contract. And that's why legal professionals are out there, is to tell you this is what you're signing, to push back to the landlord and say, no, we're not going to make that the tenant's responsibility. No, we're not going to agree to that. And really to try to protect the gym owner against these problems that are very common, because we see them across the entire United States that are very common, that pop up, that we can protect against by asking the landlord to adjust the legal language of the lease.
Absolutely. And when we signed at our newest Parkour gym, the third one we opened, when we signed that lease, before we did that, we approached you and had you, formally review it, go back and forth with us and find the things that were a little suspicious and more on the landlord's side of the fence. And I thought what was really helpful to me was you identified a couple pieces of language that were totally missing that would have advocated really well for us in our Parkour business. And some of them were like, we had some way too short amount of time, like 7 days, to get in there and make sure the building was up to code.
Right.
You gave us back, like, actually, that should be 60 days. And here is how you identify that it's up to code. You write it down, you send it to them. And when you have it in the contract in this way, it obligates them, if they agree to it, which they did, by the way, it obligates them to fix it within a certain amount of time after the lease starts. And I don't know if I ever told you this, Matthew, but that actually ended up being really critical, because once we moved in, we found electrical issues, we found HVAC issues, general mechanical on the ceiling issues, and the landlord paid for all of it. And it was in the contract. They actually didn't fuss at all. That landlord ended up being a cool guy. But I would have known to do that without your guidance on that. So thank you for that.
Very cool. Yeah, cool. Thanks for the follow-up. I don't usually get a lot of follow-up from my clients, so I appreciate that. That's nice to know you're able to do that. Very cool.
Totally. Okay, so in a different case that you helped me with, and also with that Midwest gym owner, both situations were the landlord was clearly in neglect, right? That was not doing something stipulated by the contract. So in that case, if a Parkour business owner finds themselves sort of being taken advantage of, that's their experience. From your perspective, what are the steps to take for them to defend themselves?
Yeah. So we always have to go back to, is there something in writing? A lot of problems crop up with gym owners because things just aren't in writing. And that's a big part of our mission with gym owners, is to paper this stuff. I was, just before I got on here, I was answering an email with a client asking if one of their independent contractors demanded a contract so that the contractor knew how much they were supposed to be being paid. And the gym owner was like, do I do contracts with independent contractors? And the answer is, yeah, you do, for these exact reasons, so that we can take out these questions if there ever becomes a problem. But assuming there's nothing in writing, then we really just have to look at the situation and look at who was wronged in the situation. And sometimes just do a cost benefit analysis of, is it even worth it? And so A couple of things that the gym owners should do is, do a little bit of research on their own, see if are there any written laws, statutes, case law, anything in proximity to the situation, and how did that play out in the gym owner's state. And a search on Google, a search on ChatGPT will give you maybe a little bit of suspicion about whether or not there is anything that can be done on the situation. You got to take that information with a grain of salt, because they can both be wrong quite regularly, Gemini and ChatGPT, about legal situations, especially when they start to get into a lot of specificity. You really need to start getting a little bit skeptical. But that can at least give you the thought then, well, okay, maybe there is something here that I can do. It'll give you an idea of how to push back then, or give you the impetus to call somebody like us to say, here's a situation, here's what I think I can do. What do I do? And there are times when those, gym owners will come to me with that kind of a situation, and I'll tell them, call your insurance company, tell your insurance company that this happened, and sit back and wait, because nothing else has happened yet. Or go back to the person who owes you money and tell them that you've interacted with an attorney and you believe that they owe you $5,000. And if they don't pay you, you rendered the service, you didn't do it for free, you're going to pursue them in small claims court. And sometimes that, just understanding the situation, we can give the gym owner a little bit of confidence to push back, so they don't feel like they just have to roll over.
Okay. So research, hop on Gemini or do a quick Google search, see if at a top level, your claim has some merit. Beyond that, I'm hearing if that person owes you money or they've wronged you in some dollar amount, you need to compare that to how much is it going to cost to litigate this. So if they owe you $5,000 and it's going to cost you $5,000 to retain an attorney, at that point, just how much do you want revenge? And beyond that,
right?
Beyond that, if it costs you more, then maybe you just drop it. Maybe you see what you can learn from this, and you move on. Is that what I'm hearing? Yeah.
And that's a tough conversation we have to have sometimes, is what is the cost benefit analysis here? Because even if it's like a $5,000 case, usually when we're trying to collect money, attorneys will take the case on what's called contingency, which means only if we win, only if we get money, then you owe me for my services as an attorney. And usually the standard is 33% contingency. Well, if your claim is worth $3,000 and I'm going to work on a third contingency, that means at the end of the day, I'm working for $1,000, which is instantly going to cause me as the attorney to then do a cost benefit analysis of how much time and effort do I have to put into this in order to get $1,000 out. We'll get these claims a lot, or these questions on membership disputes. Gym owner calls and says, I just had 3 members issue chargebacks. How do I get my money back? And I'll go, okay, well, how much are we talking? And they're like, $300. I get $300 is hurtful. I don't want to lose $300. But at the end of the day, what's your effective hourly rate? And how much time are you going to put into this to get $300 back? And if you guys don't know what an effective hourly rate is, reach out to Motion Mentors. They can help you evaluate, your time and what it's worth, and to understand these business principles so that you can make more effective business-related decisions.
Yeah, absolutely. And yep, effective hourly rate is how much is your earning potential per hour, Okay, so earlier you said we need to treat our parkour businesses like they are actual businesses and not just the hobby that we are now paying for. Give me a rundown on what are the steps to take to move someone from I'm a novice, I just started my business and I have no legal hygiene at all, moving towards my legal landscape is pretty secure.
Mm-hmm. Mm-hmm. So assuming that we're already functioning, meaning, you're not engaging a legal professional from the beginning. If somebody is already operating as a gym, the best thing they can do is just reach out to a legal professional and get a legal audit on everything up to the point where they are currently. So, what do they have an LLC? Do they have a corporation? Do they have the necessary corporate documentation in place to demonstrate the authenticity to that legal entity? Again, if they're already functioning, the commercial lease is out the door until it comes up for time for renewal. That's just sort of like a learn in the future type of thing. And then it usually just involves a check of their state's laws and what kind of memberships they're selling, what kind of liability waiver they have in place, what kind of services they're offering, what kind of staff they have. Because different states, like, California, you can't have contractors. You have to provide benefits. Other states, you don't need to. So a lot of it is going to be very state dependent. But it's, as long as you catch it before you get sued, you can always make up for missed time or missed, opportunities. I think what gym owners really need to understand is, like, it's ignorance of the law is not a defense if you get sued. So, we always encourage, like, you really got to reach out. You can't wait as a business owner until there's a problem, like you can as a civilian. As a normal person, you wait to get a defense attorney when you have an issue with the law. You wait to get a divorce attorney when you're getting a divorce. You wait to get a personal injury attorney when you get a car accident. As a business owner, you can't wait, because if you wait until you have a problem in order to try to get an attorney educated in that problem, you're missing something along the way. You got to get ahead of it.
Yeah. Okay. So some of the things that came up for us back in the day when we started doing this, like having a legal audit, filling in the gaps, was, and again, you said earlier, it can change state by state. So I'm just giving this as like an idea of what there could be, what work there could be to be done. There's a few things. First, on the actual business organization, like the articles and the fictitious business name with the county, we were doing business as one thing, but we hadn't filed that with the actual county. So that there was a legal loophole there that you pointed out for us and helped us patch. So that was one thing, and it even involved that we had to submit our name that we were doing business as that name to a newspaper, and it had to be published 4 times before it was like legally valid. I never heard that in my life, but you pointed it out. It was right there when I looked it up. So I did that. It cost me $100 to pay some newspaper, and there's companies that specifically do that. Will publish it 4 times in a row. Wild. Yep. Anyway, another thing that we ran into was on our job descriptions and employment contracts. We had this past employee who raised a question of like, well, if I'm working from home, they were trying to say like, I'm not getting any breaks because I'm working from home. But from my perspective, I was like, well, you're working from home, you can take breaks whenever you want. But it never said that in anywhere in that documentation. So it was pointed out to us that was just a giant hole in the paperwork. And then, of course, as we've been talking about, when we did renew some leases, when we did sign new leases, there was a whole, review it, whole plan check. One of our next milestones is actually to pay more into the security deposit to get me off the personal guarantor. Yeah, it's like one of our next big hygiene elements. Are there any others that you feel like often come up when people do these legal audits?
Yeah, the DBA is a big one. And so let's go through a really quick example. Let's just say I file my LLC. LLCs are limited liability companies, most commonly used legal entity in the gym industry in order to protect the individual owner. You guys have a corporation, no big deal, just a little bit more formal to maintain. And so let's just say I bring out a gym that's called like Matt's Gym LLC. Okay. But you come to my gym and you see that it's actually called like Matt's Fitness Heroes. I don't know. I'm just throwing something out there. Okay. So Matt's Fitness Heroes is considered in California a fictitious business name to Matt's Gym LLC. Different states are going to call them different things. fictitious names, assumed name, trade name, service name. All right, there's all kinds of different names for them. Almost every state requires you to file an additional paperwork at some level of government if you're going to operate your gym under some kind of branded different name than your legal entity name. All right. Where this gets confusing is if I did Matt's Gym LLC, doing business as Matt's Gym, reasonable mind says that's the same thing. The law says, no, it's not, because you dropped the LLC and you're functioning without your legal designation. So it's technically a different name. And that's the biggest one that we see is when the gym is trying to operate with the same name as a legal entity, they still have to go through the process to file. The other area that we really see is missed a lot is going through a process to make sure that the gym is actually compliant with whatever the state's Health Club Act or Health Club statutes are. So this may impact the gym has to register with the state, telling the state that they are a gym and they function. This may include the requirement to have written membership agreements with very specific language from state statute in the membership agreement. If they're selling a certain type of membership, like paid in fulls for 3, 6, 9, 12 months, may require them to jump through additional hoops. And a lot of the states that or a lot of the gyms who end up reaching out for legal audit just aren't aware that these statutes exist and are pretty much leaving their business open to just be shut down the day that it becomes evident that they're not compliant.
Yeah. All right. So doing a legal audit, showing obviously what state you're in, what you've done so far, and if your state requires that you have those components like your membership contracts and all that, discovering that step one, and then getting up to compliance, step two. Okay, cool. And so to kick off a legal audit, they would connect with you how?
I mean, the easiest way is just go to the website, and we have calls to action all over the website. So if you submit your information, you'll automatically be forwarded to my Calendly calendar that you can then schedule a 45-minute discovery call with me. And it's a free call, and I'll just run you through. I'll just, pick you apart a little bit in a nice way. Yeah. So we can figure out what do we need to fix, and then we'll just create a game plan in order to fix it.
And that's gymlawyers.com?
That's right. Yep.
Great. Okay, cool. All right. So I wanted to touch on a little bit of news that just came out this week. So some bonus content for you listeners, especially listeners. I think it was the FCC just said that canceling any subscription or membership, whether it be digital or a service. So all memberships, it sounded like to me, the language sounded like canceling needed to be as many steps or less than joining. So if there were 10 clicks to sign, it needs to be 10 clicks or less to cancel. 5 minutes on the phone to join needs to be 5 minutes or less to cancel. How does this impact parkour businesses?
Mm-hmm. Yeah, we were seeing this state by state a little bit. I think there were about 3 states over the last year that were trying to implement these essentially digital cancellation policies. And usually the way that the policy is going to read is however you were able to sign up is, as you said, is as easy you should be able to cancel. So if a parkour gym allows somebody to sign up through their website and come in and then just start, or come in and do a drop-in or whatever, they have to be able to provide a way for them to terminate on the website as well. If they were able to sign up via email, then they need to be able to terminate via email. And what this is potentially going to impact is, and the way that it'll shake out, and it's going to take forever for this to shake out this way, is first, the FTC's, it has to be signed into law, which we ended up with, an issue back earlier this year with non-compete clauses and employment agreements. And, the FTC comes down and says, non-competes are out, and everybody freaks out. And then within 30 days, 60 days, another government organization sues the FTC and says, no, you can't do that. That's beyond your control. And now it's locked up in court, and we can still use non-competes for a while. And that's what's going to happen here potentially too, is the FTC is going to say this, and everybody's going to go, oh, this is going to change everything. We've got to wait for it to go into law. Okay. But where this is potentially going to cause an issue is, let's go back to those states that have some version of a health club act. Okay. California's got one. Pennsylvania's got one, Texas, Florida, and all of them have a section within the statute that says this has to go in your membership agreement, and it has to say verbatim that if your client goes home after signing this agreement and has buyer's remorse within usually 3 days, 5 days, they can come back to the gym and demand a full refund. And you have to give it to them. But what those statutes will say is that this notice has to come in like via handwritten letter or certified letter to the mailing address of the gym. Well, that's because these statutes were written like 2 decades ago when people still sent letters. And there's some theory in California that even though the California statute says that an email would be acceptable. There's about 1 or 2 other states that say, and the gym owner can accept like an easier form like electronic notification order to cancel. Ohio is still saying they have to, literally the gym owner has to provide the cancellation form to the gym owner when the gym owner signs the agreement, and to the gym member. And the gym member then has to use that specific form to cancel if they want to cancel. And it's like, this stuff's just so archaic. So I'll be very interested to see if this FTC law actually does get signed into law. It should go ahead and override all state laws to say, gym owners, you can now say in your buyer's remorse clauses or via email, you don't have to have the gym member mail in a notice of cancellation.
Okay. And we're recording this episode October 21st, 2014. Matt, take your crystal ball. When do you think this might come into law?
It's 2024. Yeah, you said 2014. I don't want anybody to get super confused.
I have got the wrong crystal ball. Thank you, Matt. Your crystal ball is as effective as ever.
Wow, that's an on-the-spot question that I believe somebody has 30 days to appeal an FTC ruling. And then I think Congress has to move it through in order to get it signed into law. But don't quote me on that. Federal law is tricky stuff. I would have to go to my Google.
Definitely quoted. Yeah, I hear you.
I would have to go to my Google and double check that. But even if it goes into law, I wouldn't, maybe sometime in 2025, we have to start worrying about it.
Yeah.
Okay.
So nothing to do yet. We don't need to go blowing up our cancellation policies and all that quite yet, right. But something to keep an eye on.
Right. Yeah, and we usually do like a once a quarter kind of updates. We just threw out a blog post, I think went up, or it's going up. I don't remember what. That has 3 different updates to the laws across the U.S. that are coming into play, usually around employees. But I think actually it's Montana who is putting in a law this month that dictates how it's going to impact gym owners and how they have to store their clients' information, their clients' private information. Mm-hmm. What sort of assurances and privacy policies are potentially going to have to be added to something like a membership agreement in order to provide that information to the client about, yes, we collect your credit card information. Here's the privacy policy that says we're not giving it out or exposing it to anybody else.
Right. Okay. So if you want articles like that, go to gymlawyers.com, subscribe to their email newsletter. And anytime I see, because I'm totally subscribed to your email newsletter, Matt, anytime I see a, legal blog post come out with some updates in it that I find to be relevant for specifically parkour gym owners and parkour business owners, I'm swiping it and sharing it in the Motion Mentors Discord or the Motion Mentors Facebook, on Facebook, our Parkour Business Owners group. So if you're in one of those places, you'll see content from Matt flow out every once in a while. And like I said at the top of the call, Jim Lawyers is a brand partner of Motion Mentors. So we definitely recommend that you connect with Matthew if you want to do a legal audit, if you have just general questions, or if you're like me, like a year and a half ago, and my landlord was just really giving me a hard time Matt helped me just put the total kibosh on all of that, which thank you again for that.
You're welcome.
All right. And Matthew, any last words here?
Yeah, I'm just going to echo this sort of again. The message throughout all of this is let's work now to head off problems in the future. I think we brushed very, very quickly over the individual who thought they were owed money for a service that they provided, never had anything in writing. They were getting kind of steamrolled over it. And we're not always like the big scary suits that you see on TV. If you don't see the recording, I'm standing here in a long sleeve shirt and a vest, and I'm going to go into my garage gym in a couple hours and do my workout. And I'm going to talk to gym owners the rest of the day. Like we're not all that scary. It's not going to cost you $1,500 just to reach out to somebody like us and find out, is there a problem that we can head off? And if you don't know, you don't know. And that should be the impetus to reach out so that we can avoid problems from cropping up in your business.
Yeah. And Matthew, I've found that a lot of questions out to you, and this is similar to when parkour business owners ask questions to me. Sometimes it's just like, here's your answer, and then that's it. There's no real need for a sales pitch or a whole like onboarding process. It's just you're an expert and you can easily give them a pointer on where to go next. Similar to me, if someone has like a quick question about, marketing or sales or profitability or something, and I can't answer in just like a couple of sentences, I always do. So I'm saying that to say that, yes, give Matthew a call, give him a email if you do have a question. He is sitting here in LL Bean vest. He looks adorable. He's not a scary guy. So all good. Cool.
All right. Thanks so much, Jimmy.
Yeah. Thank you for connecting, Matthew, and I'll see you next time.
Always.
All right, everybody. That was Matthew Becker from gymlawyers.com. He's a brand partner with Motion Mentors. So if you need any legal advice or general business advice on how to make your parkour business profitable, scalable, so that your impact can reach more people and so that you are rewarded for the process along the way, just reach out and give us a call. All right. Thanks, Matthew. Talk to you later.